notify the child's birth, 1, under the name of the mother, 2, under the name of the father, or 3, where there's a joint request. So the appeal court subsection C is how subsection 10(1)(b) presently presents itself in the Act. So yes, we think that it should be there because it's currently there in the Act.
Mr. Beamer, I think where the confusion, you were referring to the respondent's 10(1)(c), weren't you, earlier?
Yes.
That's where the confusion came.
Justice Victor, I could have been clearer. I'm sorry.
Yeah.
Mr. Beamer, may I raise something with you, please?
Yes, Justice Medved.
On the same point, what appeals to me in the full court's order that's just been read out at page 14 of the judgment, page 220 of the record, is that makes provision for the surname of the father to be used where the father is the person giving notice and acknowledges paternity in writing under oath. Now, as opposed to the respondent's suggestion, which simply says under the surname of the father, of the mother, or of the father, and discarding for the moment 10(1)(c) is, there's no guarantee or safeguards against illegalities and irregularities, because one of the concerns, I think, we've never heard the respondent's version, but one of the concerns, I think, is where there can be illegalities or irregularities with fathers seeking fraudulently or falsely to register children under their names for whatever reason. And so speaking for myself, I think the full court's order appeals to me because it contains that safeguard of paternity being acknowledged in writing under oath by a father.
Justice Majid, I think that there are two issues to deal with under this topic, and it's simply this: there has to be some safeguard. And by incorporating into the Act a mechanism of acknowledgement on oath, we say is sufficient. Anything beyond that may be going too far. So for example, the requirement for there to be a DNA test, it becomes exclusionary because DNA tests are expensive. Though also we need to remember that under the Act, the Director General of Home Affairs is empowered by Section 7 to request verification of information. So should there be a bona fide and prima facie reasonable suspicion that a fraud or illegality is being committed, then Section 7 empowers the director to ask questions and require further documentary proof or proof to his satisfaction. Right? And I think importantly is subsection 7(1)(b), which says the Director General may investigate or cause to be investigated any matter in respect of which particulars are to be used for the registration thereof in terms of subsection 5. Right. So the Director General of Home Affairs is empowered to investigate. Further, there are procedures in the Children's Act where the matter can be referred to for further investigation by people who are perhaps better placed to investigate. I think, again, the most important thing is to remember that the purpose of Section 9 and 10 is to facilitate birth notification, and there's a delay from notification to registration. So notifying the child's birth does not immediately amount to a birth registration. It then goes to Home Affairs, and Home Affairs must then do their jobs. If there's bona fide concerns, they have a period within which to address those concerns, but the approach ought not to be, because there may be concerns, we're not going to notify. We say that approach is deeply prejudicial to the best interest of the child. Thank you, Justice Majid.
Well, Mr. Beamer, Justice Majid's worry is my worry. Shouldn't we clean this process up from the very beginning? I mean, human trafficking is one of the problems that we have. What stops a person from picking up a child, coming to Home Affairs, registering the child, and a man like me claiming to be the father. What safeguards are there? Should we work on the basis of assumptions, or should we make sure that guarantees are there?
Yeah. Chief Justice, it's a difficult question because I think the first time this issue was raised was in the state respondents' heads of arguments. And it's also just made as a passing comment that human trafficking exists, and it may be a concern, though the risk that we run with taking an exclusionary approach is we're saying that the general rule of fathers being able to notify their child's birth ought not to be allowed because of an exceptional circumstance that child trafficking exists. Now, to date in this matter, we haven't had an opportunity to traverse the issue on evidence. And shortly before this hearing was set down, the Center for Child Law actually published a study where they address the real concerns with human smuggling and human trafficking. And one, there isn't much evidence on it because it is such a candid illegal practice, and most of it flies under the radar. Though what the Center for Child Law also found was in many instances where rights are limited on the basis of this argument that child trafficking exists, it's merely speculation. So for this court to now deal with that issue, we say it might be stretching too far, and Parliament may be best placed to investigate the issue through its process and legislate through the act or through the regulations to safeguard those concerns. Though our primary position is an acknowledgement on oath plus the powers which the Director General already has to investigate should safeguard enough.
No, let's take this through stages. Do I understand, let's start with the mother. Do I understand your position to be that it may be open to the mother to register the father even if there is no proof, say a DNA test conducted to demonstrate that the person she says is the father is in fact the father? Or must there be an acknowledgement before the mother can register the child or notify, give notice of registration of the birth of the child and indicating that so and so is the father? Is there a need for proof that the person is indeed the father?
Chief Justice,
let me make my point clear. Let me make it clear. How do you avoid somebody approaching Home Affairs and saying, when is the father of my child? In circumstances where I don't even know.
Chief Justice, I think the difficulty is the only means of proving paternity is through a DNA test. And to make that a requirement in the notification of birth makes the process of notification unnecessarily burdened. So between notification and registration, there's sufficient time to both record the details of the child and investigate any suspicions of either a fraud or lie or misrepresentation. And if there's a bona fide concern by Home Affairs, then perhaps they can request a paternity test if it's warranted. But to legislate for that in the notification provisions may be going too far and burdening the process of giving notice too much.
Let's take it in stages. Are you suggesting that it should be open to the mother to register the father, somebody as the father of the child, without any proof that that person is the father? Or should there be proof that the person is the father before the mother can on her own register the child under the surname of the alleged father?
So the current regime is that a child born out of wedlock, because that child may not benefit from, for example, the presumption of paternity under the common law, or the presumption of paternity under Section 26 of the Children's Act, that mother will then notify the child's birth under her surname.
Right.
Now, right. The second option is that the joint request. So the father and the mother present themselves and say, I want to give this child's notification, birth notification, under either mine or his surname, but the mother is there. So
I wanted your proposals,
yeah.
not what the act says. I wanted to know what you are suggesting we should do. What are your submissions? What are you asking us to do in this? Should it be open to the mother to register the child in the names of the father, under the surname of the father, or indicate that so and so is the father without proof that the person is indeed the father?
Chief Justice, our position on that is simply it goes too far on the current wording of the Act. So
yes,
the mother being able to notify her child's birth isn't a hurdle to the child's birth being notified. The father being able to notify his child's birth is not a hurdle to the child's birth being notified. Where we start dealing with situations where the mother wants to notify the child's birth under an alleged father's surname, there we say, leave it to Parliament and let them follow the parliamentary process of debate and consultation and come up with a regime that may be different from the present regime, or may directly deal with only that aspect of it. So in the present case, that was not an issue. And again, we say on the current wording of the Act, trying to fix that now may be going too far into legislative territory.
Now, you see, page 14 of the judgment, you support B. It says, under the surname of the father, where the father is the person given notice of the child's birth and acknowledges his paternity in writing under oath. How would Home Affairs know that this is the father? What stops anybody from rocking in at Home Affairs and saying, I'm the father of so and so, under oath? And we know people do lie, eh? Even in court, witnesses raise their hand, take an oath and lie. How do we make sure that in order to protect the best interest of the child, we don't have wrong people claiming to be fathers and having themselves registered as fathers of children? How can we just leave that one open like that?
Yes. Chief Justice, perhaps we can venture into a thought exercise of what the alternative would be. So
sure.
Perhaps would it be in the best interest of the child to require in the read in subsection B that a DNA test be accompanying the notice of birth? So under the current regime, you have the requirement to notify within 30 days, and anything beyond that there attracts a fee. In many instances of the clients that the center has disclosed in their papers, these are men and women who cannot firstly afford to have a DNA test be done. So perhaps they will look for financial assistance, which may take time, which invariably pushes them into late birth registration territory. Sorry, late birth notification territory. So if we're looking at what's the best interest of the child, it's the general rule, which, well, from what we see, is it's normal people who are fathers and want to notify their child's birth but can't. So we're saying that all those people ought not to be allowed to simply notify the child's birth because of the possibility that some people may be up to something a bit more dubious. So having the DNA testing built into the act now may cause more trouble than it seeks to solve.
Well, it may not be DNA, Mr. Bima. You see, we had, for instance, I mean, it's public knowledge that we had an incident in the Western Cape of a child being taken and registered by someone else, and it was only when the child was much older that it became evident that that child who was made out to be so-and-so's child is in fact not that child. So there is a need, there's every reason to be cautious here. I mean, it doesn't have to be DNA. What about relatives? What about grandparents? What about people who can support the claim that this person giving notification is in fact the father? In other words, what basic safeguards are there to make sure that I don't just go about registering other people's children as my own? Remember, the child doesn't even have to be there. I simply have to know that there is a child born on this date, and these are the names of the child, and then I give my name in as the father. That's how loose the process seems to be.
Chief Justice, I think we need to remember that notification and registration does not happen simultaneously. So when you notify a child's birth, you are telling Home Affairs that this child now exists, this child has a name and surname, right? Attached to that would be the details of the person notifying the child's birth.
Yes.
That is then given to Home Affairs, and as I said earlier, Home Affairs has powers to investigate, and they ought to. Though, if we're looking at alternatives to DNA testing, I don't know, fingerprints, you see, so we're creating a record of facts. So we know that child A with a name and surname, her birth was notified by Mr. So-and-so. We have his name, we have his surname, we have his fingerprints. So we are now creating a record of facts. So should these exceptional circumstances arise, we have the facts to solve this, to solve the problem. The risk of legislating the exceptions away is that you block ordinary people who simply wish to notify their child's birth from being able to do so, because then there's no record of the child being birthed, the child being born. There's no record of the persons claiming maternity or paternity of the child. And again, that's why the appeal court recognizes that these children become invisible, because there's no record of either their birth or the people who are notifying their birth.
Maternity is simpler because people give birth in hospitals and records are kept and you can produce those records, can't you? But not so with paternity. As in line with page 14, that 2.2b, all I have to do is approach Home Affairs and say, I'm the father. You don't seem to need anything more. I'm the father of so-and-so, and give notice. Maybe Mr. Jamie would be very helpful because of what appears at paragraph 41 of the respondent's head. He says, Home Affairs is in the process of drafting regulations to prescribe that types of acceptable supporting documentation required when parents give notice of the birth of the child. I think that could help.
Yeah.
But for me, just to give notice like that without anything to support my claim that I'm a father, I'm worried about it. Because anybody can just give that notice then.
No, Chief Justice is correct that anyone can. And we're saying that before this court, it's merely a thought experiment. So we don't know what the prevalence of such practices are. But what we do know is that of the cases put forward by the center, these are ordinary people who just need to have their child's birth notified. Once the notification happens and there's a paper trail of facts recorded, then
which
Home Affairs...
Which facts?
Pardon?
What are the facts in relation to which there should be paper trail?
that the child was born, where the child was born, who the father of the child is, who the mother of the child is. Right. So remember, when we look at section 10, we're saying what surname ought to follow the forename of the child born out of wedlock on the notification. It's simply that. There's still a process that follows afterwards. So again, the risk is that we legislate ordinary people out.
No, I appreciate that. I'm just worried about the dangers. As we correct the discrimination, we mustn't open the door for more problems.
No, sure. And again, we say that Parliament is best placed to deal with that. And
what you know where my worry is, Mr. Bima? What happened in the 2 years, which may even be extended? What happens in the 2 years if there are possible loopholes alluded to by Justice Majid, and we don't seek to understand what safeguards exist in the interim? A lot of damage can happen during this period. If we just say, well, Parliament will fix it, what happens in the interim?
Yeah. Chief Justice, my junior's just given me answers very thankfully.
Yes.
I think there are two things that we need to be cognizant of. That the Children's Court is empowered to provide paternity orders. That may be a solution to the interim issue. So have the birth notified, and if there's a suspicion, then Home Affairs can require a paternity order from the Children's Court.
Can I just stop you there? The Children's Court can take many years to finalize paternity, even 5 years. But it is a factor one can look at, but it's the problem of time and the court roles.
Yeah.
What is the next one that your junior?
Justice Victor, so again, it's entering that process just causes further delay. So we simply saying, let the birth be notified and there's room to confirm later. Secondly, the late birth registration application form from the Department of Home Affairs requires a reference person for the child. So the law already requires a reference person in addition to the father notifying for all late birth registrations.
And Mr. Bima, I take it that I know you don't represent Home Affairs, but you're saying we can take comfort in the readiness of Home Affairs to vigilantly ensure that the necessary safeguards are in place.
Yeah. Chief Justice, I think that may be going too far on what our position is. We're simply saying that we need to facilitate birth notification. And the risk that the child bears in the absence of birth notification presently outweighs any of these concerns, because Home Affairs, as the state has said, is considering these issues. So is considering this issue, and it's perhaps best left for them.
Yes. Well,
you see, unfortunately,
yes, carry on.
Sorry, Chief Justice. Unfortunately, when we create the distinction between children born within and without of wedlock, you have a class of children who benefit, for example, from the common law presumption of paternity and the rebuttable presumption of paternity under the Children's Act, and then you get those who simply don't. You see, so on the one hand, a father needs to simply exist. On the other hand, the father has to can't notify the child's birth, and then has to take a number of steps to do so. So it's a delicate balance of issues that need to be considered.
I think there's some difference there, Mr. Bima, isn't it? Because when the two are married, everybody in society knows the mother there, the is so and so. So when the child is born in that family, and there is even a marriage certificate, it is easier for the father to approach Home Affairs and say, I'm married to so and so. Here are hospital records. The child was born. So as the father, I'm coming to register the child. But on the other hand, you have a man who approaches Home Affairs and says, such and such a child was born. I'm the father. But you've got no way of satisfying yourself that the person claiming to be the father is indeed the father. And for the sake of protecting for the sake of the child, you need to be a little bit more cautious. It's not just a question of discriminating the married against the unmarried. No, it is a question of ensuring that people don't just rock up and have an easy adoption, which is not properly processed, just by acknowledging paternity and claiming to be fathers. That's the difference. It is not just wild discrimination. You just want to make sure that the one claiming to be the father is the father. Otherwise, we'll easily grab children, be fathers, and leave the country with them and do whatever we want to do with them.
Yeah. Chief Justice, I take your point, though we need to also remember that, for example, in the cases presented by the Center for Child Law, the mothers of the children were undocumented. So in terms of South African law, they might not be capable of entering into a civil marriage, though for all other intents and purposes, they live and enjoy life as a married couple. See, and family unit. So again, it's a very delicate balance, and we need to be cautious not to legislate for the exception at the risk of excluding the general rule.
All you need is a basic way of satisfying Home Affairs that the person claiming to be the father is the father. Yeah. It may be DNA, it may be grandparents, it may be relatives, it may even be the mother's friends. Some way with the names and details, some way of satisfying yourself that the person claiming to be the father is not just easily accepted as the father without verification.
Sure. Chief Justice, and perhaps the best approach would be having a requirement similar to what the department has in the late births registration application form. So there's an acknowledgement of paternity with some third person either verifying or confirming knowledge of the child's birth, knowledge of the child's mother, or knowledge of the person notifying, the man notifying as being the father. So I think we can go that far in creating a safeguard in the interim, though, again, we need to be careful not to place too much of a burden on having the birth notified and having a birth registration certificate issued. So I think we've covered the delicate balance that the court needs to consider. And that's probably the best balance.
I'm sure Mr. Jamie will be very helpful, but before we part and before he comes in, my worry is this, Mr. Bima. It can't be denied that corruption is rampant in South Africa. Whether it relates to tenders, whether it relates to child registration, it respects no territory. And that's where I'm coming from. Fraud and corruption is a serious problem, and the likelihood is it may permeate even the child registration situation. Therefore, we need to be vigilant as we make orders, not to make orders that can play right into the hands of corrupt characters out there, human traffickers out there. We've got to be vigilant and make sure that basic information is at least in place to give us that comfort that we are not giving away, or Home Affairs is not left to give away people's children as a result of lack of vigilance.
And perhaps that's why more emphasis must be placed on recording facts. Thank you, Chief Justice.
Thank you. Mr. Jamie?
Sorry, Chief Justice. Mr. Bima, do I therefore understand you to concede that there are legitimate concerns regarding, for example, the trafficking and kidnapping of children, that may be why extra or different measures are required when unmarried fathers wish to give notice of the birth of a child and assign a child's surname.
Thank you, Justice Kampepe. It's a difficult question to address in this court because neither the High Court nor the Appeal Court had considered evidence on this. So it's an issue that, I mean, we can concede that it is a concern, but we don't know what the prevalence and the frequency of it is. It may be something that is overstated in society or understated. There's just no way of knowing. But we can recognize that I think globally, human trafficking and smuggling is a concern, though we need to accept that in the present case, it's just not, the facts aren't before the court.
Sorry,
so I
just
would go as far as to say that the center, concedes on the point now. We say it's best left to Parliament to perhaps call for comments on a proposed bill and have the people who have the data and the actual facts, have them play a part in the process so that it can be legislated. Thank you, Justice Kampepe.
Sorry, just one last question, Chief Justice. Mr. Beamer, if one added some words to your proposed 1B, for example, in writing under oath and an affidavit from a third party who knows both mother and father, something like that, for the interim, so that there's no abuse in the interim. How would that do?
Yeah, Justice Victor, I think that approach strikes the balance between going too far and not having sufficient safeguards in place. So I think that approach probably addresses Chief Justice's concerns that he just raised now, and perhaps maybe even to some extent allay the fears that Justice Kampepe has raised now, while acknowledging that Parliament may be able to deal with the actual data of the prevalence of the issue.
Mr. Bieber?
Justice Matapo, yes.
I see you are attracted to the suggestion by my sister about the third part. My biggest problem is if we are talking about corruption and you will still have the third party going before the Home Affairs, deposing to an affidavit based on falsity. So it's no solution to the problem at all.
Justice Matapo, perhaps if we look at the risk of not notifying the child. So let's take a hypothetical situation of this elusive man who is trying to be dubious. Are we saying that the man presenting himself with the child ought to be sent home with the child without any record of either the person attempting to notify, whether it's legally or illegally, and without a record of the child? See, I think that there would perhaps be a more dangerous situation to leave the child in, as opposed to then creating a record of facts in the department's system of who this man was, taking his fingerprints, perhaps having a verifying affidavit accompany that, but more importantly, recording the details of the child. So if it would mean taking fingerprints of the child, though we now have the child within the Home Affairs system, as opposed to sending the child home with a dubious man, all of whom are a ghost in the system. See, so again, it's a situation that Parliament needs to consider, though we can't perpetuate the problem of having children go unnotified, who have bona fide fathers wanting to notify the birth. You see, so as long as the record is created, Home Affairs can now find these people, and the risk is it's either that or sending the child back home with this dubious man.
Mr. Beamer, shouldn't that
Justice
be the problem? Shouldn't that be the problem of the department, which Mr. Jamie has said in paragraph 41 of the heads, that the department is looking into ways and means to ensure that such exigencies do not happen. But for the purpose of this case, your paragraph A, B, and C, and Parliament, when it decides, it may very well say we should insist on a DNA, but at the same time, take into cognizance the fact that most of the people may not be able to afford those DNA tests.
Yeah. Just Matapo, again, it's we need to accept that Parliament may decide to put stringent requirements in place. So as Justice Matapo says, a requirement that there be a DNA test and so on. Again, Parliament is probably best to decide what they're going to do. And remember that they're still subject to the parliamentary process. So there may be comments coming from sectors of society that says that goes too far and it may not pass the House. Though for our present purposes, we are faced with a question of under-inclusiveness, and we need to seek to create an inclusiveness in that section. And the point is to facilitate notification of birth. We shouldn't lose sight that if a child's birth goes unnotified, that child is now a ghost. And if the concerns of child smuggling and trafficking are have any thrust to them, then it's especially more so that the notification be accepted and a record be created, as opposed to sending the child back home.
Yeah. And Mr. Bima, your 73.4.1.2 says, under the surname of the father, where the father is the person giving notice of the child's birth and acknowledges his paternity in writing under oath, you accept that anybody who comes and say, I'm the father, and acknowledges in writing under oath is the father. There doesn't seem to be any mechanism to prevent just an imposter coming and saying that he is the father, when in fact he's not the father.
Chief Justice,
it's
again,
just a loose provision.
Yeah, Chief Justice, again, we acknowledge that it's a possibility. Especially, I think, in this day and age where deposing to an affidavit doesn't have the weight that it may have once did. It's thin. So again, the difficulty we have is we don't know what the prevalence and frequency of such conduct is in the specific request. You see, so again, it takes us back to, yes, we recognize that it's a possibility and it probably happens, but we don't know how often it happens. And again, we are looking at an approach where we don't exclude the majority because we are concerned about the exceptional few. And again, we in this case, it's unfortunate we simply don't have any evidence. It would have been probably best dealt with in the High Court. Yeah. Thank you, Chief Justice. Yeah. Chief Justice, I think I've covered all the points that I intended to cover. I don't know if any of the other justices have questions. If not, I think I've said my say.
Thank you very much, Mr. Bima.
Thank you, Chief Justice.
Thank you, sir. Mr. Jamie?
Good morning, Chief Justice, Justices. Having listened to the debate between my learned friend and the members of the court, I think has provided clarity and perhaps crystallize the issues. Can I perhaps get immediately, and perhaps I can start off with the point raised by Justice Victor, which in our respectful submission goes to the heart of the problem, and which is why we, with respect, say that the Court of Appeal found Section 10 to be under-inclusive, but it did so insufficiently, it did not go far enough. And that is because the fundamental problem with Section 10 in our submission is the fact that it distinguishes, improperly we submit, between children born within and out of wedlock. And that is a distinction, Justices, which we've said in our heads of argument, and I don't think it's an issue in the matter, harks back to a past where children were regarded as, they had a different, I wouldn't necessarily say lesser, but they certainly were distinguished by the fact of whether or not their parents were married when they were born. And that is a distinction which we respectfully submit can't withstand constitutional scrutiny. And
may I interrupt you, Mr. Jamie, but is that correct? I mean, when a child is born in your family as a married man, whether you're actually the father or not, society is bound to assume that you are the father. It's in your house that the child is born.
I'm sorry, Chief Justice, I'm not hearing you clearly.
I'm saying, as a married person, yes, when the child is born in your family, in your home,
yes,
we all just readily believe or assume that you are the father. And if you approach Home Affairs to register that child as a father, it ordinarily ought not to be surprising. It's different though. When I go to Home Affairs and say, that child who was born in Johannesburg on this day is my child, and give notification of birth, without anything attaching me to the child except an affidavit. I think that the struggle is, how do you as Home Affairs satisfy yourself that the person claiming to be the father is the father? But otherwise, there shouldn't be any problem, I agree with you, if there is something to hold on to, on the basis of which you satisfy yourself that this person claiming to be the father is the father.
Chief Justice, could I attempt to answer that question on two levels? The first is the level of principle, and second on the level of practicality. On the issue of principle, our submission is with respect that although society in certain situations, I don't accept that it's in all situations, more readily accepts that a child born in wedlock, to use that term, which itself is an archaic term with respect, is the progeny of the father. That, with the greatest respect, is itself an outmoded way of thinking, and there can be, and we all know there are many exceptions to that that scenario, that a child born to a married couple is necessarily fathered by the male in that relationship. So that's on the level of principle. I respectfully submit that notwithstanding society's norms and to some extent outdated values, there is no greater certainty that a married man who presents himself at Home Affairs can say with any greater degree of certitude that he's the father than an unmarried man who may be in a relationship with a mother for many years, but just they've never, through choice or circumstance, gotten married.
If I may interrupt you, Mr. Jamie, but what risk does it pose to the interest of the child if that man, who may actually not be the natural father, the biological father of the child, who lives with the mother, goes to register the child in his names? How will it jeopardize the best interest of the child in contradistinction to a person whose fatherhood, whose relationship with the child is difficult to verify?
With respect, Chief Justice,
because at the end of the day, we just want to make sure that the child is well looked after, the best interests of the child are protected. So how does that pose the risk to the best interest of the child?
Because it's not necessarily, Chief Justice, in the best interest of a child to have his parentage, well, let me rephrase the answer. If the court's concern, which it appeared many of the justices had, and I'm going to answer the question as I indicated on the basis of practicality as well, but we're dealing for the moment with the question of principle. It's in my submission, it's in the best interest of the child that his parentage be properly established, and whether that is has the awkward circumstance that is not fathered by the husband of the mother, that might be awkward, but I do not, with respect, accept that it's in the child's best interest that his parentage be accorded to someone who in fact is not his parent. And if I can now try to answer the question on the practical level, there are regulations, which, as you know, the Court of Quo, Bodlani AJ, found the regulations to be unconstitutional in various respects. And he read into earlier the words where available before Regulation 3.3F. So to now provide that only where available must a certified copy of a passport and visa or permit be accompany the child's notification of birth, where one parent is a non-South African citizen. But the fact of the matter is, Justices, there are a range in Regulation 3.3 of the regulations as they stand, and as they still stand, there are a range of requirements which Home Affairs has at its disposal upon the birth, upon the notification of the birth of a child. They include inter alia biometrics in the form of a palm, foot, or fingerprint of the child whose birth is sought to be registered, and the fingerprints of the parents, which have to be verified online against the National Population Register. And where they cannot be so verified, a full set of fingerprints of the parents must be taken on a specified form. So that's among the ways in which Home Affairs, the officers, verify the details of the child, and that's regardless of whether or not the child is born within or out of wedlock.
Mr. Jamie?
So we submit, I'm sorry, Chief Justice.
Sorry to interrupt you, Mr. Jamie.
I'm sorry, Justice.
Following on the question that the Chief Justice had posed, in your written submissions, you contend that the reading in proposed by the applicant and endorsed by the full bench gives rise to a real possibility of abuse because, for example, a kidnapper could falsely claim under oath to be the child's father.
That is correct.
Please, can you clarify for me how the reading in proposed by the state respondents in respect of Section 10(1)(b), which does not require the purported father to make any averments about his paternity under oath, mitigate the potential for such abuse?
Justice, Tron, I don't for a moment pretend that the matter is an easy one to resolve, this question of the interim reading in. I find myself entirely in agreement with my learned friend for the applicant for confirmation that it is a matter best left to Parliament. And it is precisely for that reason that what we suggest as an interim reading in, and upon consideration of the issues put to my learned friend by members of the court, we may want to revisit our submission as to a reading in, because with respect, Justice Tron, we submit that Section 9.2 of the Act, and you will note that 9.2 mirrors, or rather our reading in mirrors what 9.2 at present says. And that has not been the subject of any finding of unconstitutionality. So that provision, which, just to remind the members of the court, says, subject to the provisions of Section 10, the notice of birth referred to in subsection 1 of this section shall be given under the surname of either the father or the mother of the child concerned, or the surnames of both the father and mother joined together as a double-barrel surname. So that provision is on the statute book as it is, and we submit, upon consideration of the issues raised by the court with my learned friend, that that should suffice. And the court, in fact, does not require any further reading in, because the verification procedures are not provided and should not be provided by the Act, because of the infinitesimal range of possibilities which arise. And the Act can never, with respect, can't be expected to cover every eventuality. And for that reason, we submit that the work of the regulations, or rather the work of verification, is not to be done in the Act and the various permutations of a revised Section 10, but is to be done by the regulations and proper application thereof by the officers of Home Affairs. And once the opportunity to have the child registered in any one of the three manners, the child's name, sorry, registered in any one of the three manners contemplated by Section 9.2 is appreciated, the need for any reading in and rewording of Section 10 falls away. And the simplest, I hesitate to use the word most elegant, but certainly we submit upon reflection, Justices, the simplest interim remedy would simply be a striking out of the entirety of Section 10 with no accompanying reading in. Because, as I say, Section 9.2 does the work that Section 10 attempts to do, albeit confined to children born out of wedlock. And for the reasons that I... Sorry.
Sorry to interrupt you.
Justice.
While we're on the question of regulations, you also say that the regulations which require a parent to furnish various documents, as well as Section 7.1 of the Act, which allows the Director General to call for proof of correctness of any particulars furnished to the department, minimizes the potential of abuse in relation to the reading in that the state respondents propose. But does that section not equally apply to the reading in proposed by the applicant and the full bench?
The difficulty with the reading in proposed by the applicant, Justice Tron, is that it would supersede in a particular situation, namely an unmarried father who can't obtain the cooperation of the mother. It would supersede the regulations because, in other words, the reading in would render the relevant regulations nugatory in respect of one particular class, namely the type of father that the centre acts for, that the applicant acts for. And with respect, we submit that is an intrusion into the powers that the legislation quite properly accords the executive. And the court should not, as it were, carve out a particular niche for a particular type of litigant, which then places that litigant in a different or superior position to every other applicant who applies for registration of a child's birth. And that is our principal difficulty with respect. The criteria of both the paragraph 14 of the judgment and our learned friends reading in that they seek in the heads of arguments, and more particularly in para 73.4.1 on page 37 thereof, we submit that is unwarranted intrusion into the proper domain of the executive. And for that reason...
Mr. Jamie, I don't quite follow that argument. Are you saying the constraint that identifying arises because of what the regulations provide, or am I misunderstanding you?
I'm sorry, I can't see who, on my screen, I can't see who the speaker is. My apologies.
Can you see now?
It's Justice Madlanga, Mr. Jamie.
Is it Justice Madlanga? I'm sorry, you're not coming up on my screen, Justice.
Did you hear the question though?
I did hear the question.
Gallery view.
Go to gallery view. Sorry, my apologies. Thank you, Justice Madlanga. Our position, I'm sorry, do you mind just putting the question to me again?
You seemed to identify some constraint or difficulty or problem. So my question was, I don't quite follow the argument. Are you suggesting that that constraint arises as a result of what the regulations provide?
No, Justice. I was attempting to address. Yes. Sorry, I was attempting to address the question put to me by Justice Tron, which was in relation to the difficulty that we had, and why we had a difficulty with the reading in of the applicants. And that difficulty does not relate to the regulations. Our position, Justice, is that the regulations, which are not under attack or, well, they were under attack in the court, I quote, but they're not a topic for discussion in this matter before the court today. The regulations stand with the changes that were read in by Acting Judge Bodlani. So the regulations bind the Home Affairs officials and officers who attend to registration of birth. And if, as my learned friend for the applicant quite correctly points out, there are remedies that both in the regulations and Section 7 of the Act, where the Director General or any of these delegates can undertake further investigation if they think there's something not right about any particular application. They can take steps to verify. So we submit that is quite properly what the regulations provide for, and it provides for that across the board, both in the case of documented and undocumented parents, and in the case of parents married or not married. Our difficulty.
Can I just ask you? You talk about in this case, there's an undocumented mother, and for years the third and fourth they've not been able to register the child, Novuyo. There's also the case of Vusi. There's also the case of AK after 29 years, without the mother being present. There's a huge group of children, adults, and it'll become generational, as Mr. Beamer said. What is to be done? I mean, can that be corrected by regulations, specific regulations? Or must Section 10 be deleted, invalidated?
The difficulty of verification, Justice, and I act for the Department of Home Affairs, but as you know, we were not involved, and I must apologize on behalf of my client that we were not involved at the level of providing affidavits to make this court's job easier. But that being said, on face value, those cases amount to a total failure of the system and should obviously be addressed. And I'm sure I can indicate to the court they will be addressed. And certainly our advice to our client will be to address them as speedily as possible with whatever mechanisms there are. But that speaks to verification. The problem with Section 10 is the principal one that I've raised, and that is that it distinguishes, it differentiates, let me not say discriminates, it differentiates between married and unmarried parents. And we submit that simply shouldn't be allowed in this day and age and under our Constitution to be persisted with. And that is why we submitted in both our heads and in argument this morning that the finding of unconstitutionality does not go far enough in our submission. And the solution we would respectfully submit, having heard the argument, we attempted to make it perhaps less radical by reading in a mirroring of Section 9.2. But upon reflection, the alternative, which we submit is cleaner, is to simply delete Section 10 in its entirety. It serves no proper constitutional or legislative purpose, given, and you know that Section 9.2 was introduced in 2002 as an amendment to Section 9. Before then, it wasn't there. But it now is, and given that it is on the statute book, it covers the work that Section 10 attempts to do, but we submit unconstitutionally.
Mr. Jamie, if we delete Section 10 in its entirety,
yes,
what would be Section 9? There's a reference to Section 10. Would you have to do anything about that?
Sorry, I'm terribly sorry. You're quite correct. The introductory phrase subject to Section 10 would have to be deleted as well.
Now, can we just do that without having had any argument in respect of Section 9?
We submit that you can, Justice. It's within the powers that the court has. The court, we've cited the authority in our heads of argument. The court will, in confirmation hearings, make an order which obviously will be constitutionally apposite for the needs identified. And this court is not a mere rubber stamp of the court or the Court of Appeal. It will apply its own mind, and ultimately it is the guardian of the Constitution. So to the extent that a lacuna is identified, we submit that that will be addressed by this court in terms of its inherent jurisdiction and, of course, in terms of Section 172 of the Constitution. So we submit it certainly is within the court's purview and really all that we are suggesting, justices, is an adumbration, as it were, of the reading in that the Court of Appeal has already provided. But we say, for the reasons I've submitted, it doesn't go far enough.
Mr. Chairman, if I could take you, sorry to interrupt, to section 9.2. You're suggesting the deletion of the words subject to the provisions of section 10. And then you're left with the notice of birth can be given by either parent.
That is correct. And we submit, and what it also does, of course, it gives you the three alternatives, which we submit, accords with our view as to the requirements on home affairs. They should be able to accept the child's notification of birth on any one of those three scenarios. The verification issue is an issue best left to the relevant officers in terms of the existing regulations and the provisions of Section 7.
So a mother without papers, the child will not be prejudiced if she doesn't have papers. And then you won't have the C's and the AKs and the Novuya situation.
Justice Victor, I submit that the child would not be prejudiced by what we are proposing. And the situations that you've identified or that are identified in the papers, I can only once again give the court as counsel the assurance that we will, a senior member of the department is on this platform at the moment. He's responsible for legal compliance, and I'm sure he will take to heart what the court's sentiments are. But we will certainly convey it in very clear terms. Yes, Justice.
I have two difficulties with your suggestion that Section 10 be deleted. The first would be Section 10 deals with notice of birth. There would then be nothing governing the notice of birth and the giving of the notice. Section 9.2 deals with the surname to be given to the child, but it does not deal with how that is to be done. The second difficulty would be you referred in your answer, your previous answer to Justice Victor and to Justice Mhlantla in response to the proposal that Section 10 be deleted, that the verification process can continue thereafter. Now, what verification process are you referring to, and when would that start?
Justice, I'm sorry, once again, my screen is not identifying. I have it on gallery, but it doesn't give me all the justices. So my apology. Yes. Section 7 of the Act, as it reads at present, authorizes the Director General may require the person who has furnished any particulars in terms of this Act to furnish the Director General with proof of the correctness of such particulars, and the Director General may investigate, of course, to be investigated any matter in respect of which particulars are to be used for the registration thereof in terms of Section 5. And then subsection 2, if in the course of the administration of this Act comes to the attention of the Director General that any particulars in respect of any person in any document submitted or preserved or included in the population register are not correctly reflected, the Director General may supplement and correct such circumstances. So it happens in our submission upon the information reaching the officers of the Director General. officers as in employees of the Director General. Clearly the Director General, him or herself, won't be seized with each and every case. So it's when the possibility of incorrect information reaches the attention of the relevant officials who are tasked with registering birth. With regard to Section 10 dealing with notification, could I just indicate to the court that Section 9.1, which remains obviously untouched by the court quo's judgment, provides for, in the case of any child born alive, any one of his parents, or if the parents are deceased, any of the prescribed persons, obviously prescribed in terms of the regulation, shall within 30 days after the birth of the child give notice in the prescribed manner. So that is the principal provision to give notice. 9.2 then provides for the manner, or rather the surname, under which the child can be registered. And then 10 deals only, as the heading indicates, justices, with notice of a child born out of wedlock. So it's not the principal provision providing for notice. It's specific to children born out of wedlock, which is our difficulty, which is why from the outset we've said it's under the court quo. Finding of unconstitutionality is under-inclusive. It should have been directed with respect to the fundamental difficulty with Section 10, which is that it improperly distinguishes between children born within wedlock and out of wedlock. And that remains our position as a principle.
Can I just clarify that I understand you, Mr. Jamie? I'm sorry to interrupt you.
Certainly.
So your submission now is that because Section 10 is a special dispensation for children born out of wedlock, if we simply delete the whole section, both children born within wedlock and out of wedlock will be catered for. And you are saying that our anxieties and concerns about abuse and all of that will be dealt with in terms of the regulations and in terms of Section 7.
That is
your submission.
Those are our submissions, yes. And I would add to that it's impossible for this court, or any court we submit, to attempt to cater for every possible eventuality. And that is the principal difficulty we have with the reading in that our learned friends argue for, and with the Court of Appeals and reading in. It caters for one eventuality, but it with respect, doesn't cater for everyone conceivable eventuality, and it then gives you a special dispensation in one particular case, which is understandable because that is the case which the applicant brought to court. But it's a sin of omission and commission with respect.
Mr. Jamie, you mentioned in your submissions at para 41 that the department is in the process of making amendments to the regulation. How far is that process?
I can't give you any further specificity than what is contained. We were instructed that they are in the process of doing so. It obviously is not dependent, although it might well be guided, probably will be guided by whatever this court's judgment says, but it flows from the Budlani AJ judgment, and that process is ongoing. But unfortunately, I don't know how far the process is.
Mr. Jamie?
Yes,
I may be with you on Section 10.2, as yes. I have great difficulty in what that section means. But my concern remains in deleting the entire Section 10 is that any father could go with the child and say, this is the child. I'm the father of this child. This is on the proposal of the state respondents with absolutely no proof at all. And that child could be registered under his surname. You see, with the mother, we do also have the security of the the birth report as well. But with the father, we got absolutely nothing. And if I understand you correctly, that is what the state respondents are proposing, that a father could go to Home Affairs and say, this is my child, register the child under my name with nothing more.
Well, maybe before you answer my sister's question, Mr. Jamie, just to qualify her question, not a father, a man.
Amen.
A man can go to Home Affairs and say, I'm the father. That's the problem.
Yes. Justices, can I just once again refer to the regulations? So Regulation 3.2 says where both parents of a child whose birth is sought to be registered in terms of subregulation 1, and subregulation 1 repeats 9.1, section 9.1, are deceased, the notice of birth must be made by the next of kin or legal guardian of the child. Then Regulation 3.3 provides for a list. Well, firstly, it provides that a notice of birth must be given by, where possible, both parents. So that's the default, the desired default position is both parents should be present, but it's where possible. And then among the requirements for registration is proof of birth on a particular form attested to by a medical practitioner who attended to the birth or examined the mother or the child after the birth, an affidavit attested to by a South African citizen who witnessed the birth, where the birth occurred at a place other than a health institution, the biometrics I've already referred to, palm, foot, or fingerprint of the child, fingerprints of their parents, or as you've correctly put to me, Chief Justice, the alleged parents, or the alleged father in any event, a certified copy of that identity document of the biological or adopted mother or father, or both parents, of the child whose birth is sought to be registered, as the case may be, with a reading in by Justice Bodlani, where available, a certified copy of a valid passport and visa or permit, where one parent is a non-South African citizen, where applicable, a certified copy of a death certificate of any deceased parent, where applicable, a certified copy of the marriage certificate of the parents, where applicable, a certified copy of the identity document or valid passport or visa, and where applicable, Form DHA 288B. So those are the list of requirements. And obviously, as the Chief Justice pointed out, unfortunately, fraud and corruption is rampant in this country. And there are always going to be possibilities of someone doing something for nefarious purposes. And the bulwark against that, with respect, is not to attempt to provide for every eventuality which we submit simply cannot be done feasibly, but is the alertness and the professionalism of the officers who are charged with that responsibility. So the court must, with respect, have some faith that the officers of Home Affairs will do what the law requires of them, and that they will trigger these provisions. And I just want to find, there is a particular regulation which, verification, approval, or rejection of notice of birth is provided for in Regulation 6. And it inter alia gives the Director General the power to refuse registration if he or she thinks that there is reason to doubt the veracity of any information provided to him or her, and must inform the parents in writing of the rejection of the notice.
Mr. Jamie, may I raise something with you?
Of course,
pursuant to the concern that I raised right in the beginning, excuse me, with Mr. Bima, and which has been pursued by some of my colleagues.
Yes.
When you ask for the complete deletion of Section 10, it means that the regulations which fall under Section 10, that would be 12 and 13, would also fall away. Now, one of my difficulties is that Regulation 12.2c talks about an unmarried father having his fingerprints verified online against the National Population Register.
Yes.
And where that father is a non-South African citizen, those fingerprints would not be on the register, and that father must submit a certified copy of passport or permit, as the case may be.
Yes.
If we are left with Section 9, then the only regulation then would deal with this would be Regulation 3, and the list that you've read out of Regulation 3.3 contain no such provision for unmarried fathers who are not South African citizens. That's the one problem I have. And the second problem I have is that is the one mentioned before, that I said that your suggestion does not have that additional safeguard of a statement under oath by the father acknowledging paternity. Those are the two difficulties I have if we completely jettison section 10 as you suggest now.
Thank you, Justice Majid. Could I point out that Regulation 33D does have a provision that the fingerprints of the parents, it doesn't specify married, unmarried, or citizen or not, shall be verified online against the National Population Register, provided that where the fingerprints cannot be verified online, the full set of fingerprints of the parents shall be taken on a particularly specified form, which is provided for in the regulations. So that concern with respect is met, Justice Majid, by the present regulations.
Yeah.
With regard to your point that at least if the reading in proffered by the applicant and by the Court of Appeal is accepted, there's at least the comfort of the statement under oath. With respect and without wishing to appear overly cynical or jaundiced, the remark by the Chief Justice is opposite in that regard. Many things are said under oath that may not be true, and it might give rise to a false sense of comfort to have someone with no other proof simply saying under oath that he's the parent. And the difficulty remains a principial one, Justice Majid, because it would be legislating for a particular scenario, which takes, in other words, if you provide the reading in that is sought by learned friends and by the Court of Quo, or the Court of Appeal rather, in respect of B, which is now contained in 73.4.1.2 of the heads of argument, it will trump, as it were, as we understand it. That provision, if you read it in, will trump the carefully crafted regulations, because the father or the applicant could say, yeah, I've given you the statement under oath, you don't require anything further of me. And that's our difficulty. That's the principal difficulty. We submit everyone should be treated equally, that's in terms of the Constitution, but also as a matter of practicality. It should be left to our officials to be able to verify and to investigate should they need to. They shouldn't be burdened with an order that carves out a particular niche for a particular set of applicants. That we submit would not be proper, and it's the problem of a law of unintended, or the principle or the law of unintended consequences. You might be doing more harm than good with respect, should you read that in. So to conclude, Justices, our submission is the one, as I say, as a matter of principle, we were prepared to live with what we say should be the reading in, if you're not with us, that section 10 be deleted in its entirety. We submit that an appropriate reading in would be that set out in para 63 of our heads of arguments. And to the extent that the court is not prepared to jettison we submit no longer appropriate reference to a child born out of wedlock, it should then cover those three scenarios, under the surname of the mother, the father, or double-barreled one. And we submit that resonates with section 9.2, which is, as we say on the statute book. Section 10 is, it does no justifiable good, and it does no justifiable work other than differentiating improperly, we submit, between married and unmarried parents. And that is not a relic of the old order, which this court should permit to continue to stand. So that would be our principal submission, Justices, would be section 10 be struck out in its entirety, and that section 9 section 9.2 have the word subject to the provisions of section 10 struck out from it. That would leave the remainder of section 9 constitutionally compliant, and it does the work for all notifications and leaves nothing, and obviously the regulations remain, except insofar as Justice Majid quite correctly points out, insofar as they may be a relic regulations 12 and 13 are relic because they refer back to children born out of wedlock. They will no doubt receive the attention of the Department of Home Affairs in the rewriting of the regulations which they are presently engaged with. So those would be our submissions with respect.
Mr. Chairman, just one conundrum. If you look at Regulation 3F for the undocumented parent.
Yes, Justice.
Then you'll still need a valid passport and a visa or a permit where one parent is a non-South African citizen. Aren't we back to the difficulty? Perhaps you can answer that.
Justice Victor, that is the provision I spoke of, which has had the words "where available" added by Justice Bodlani. So it now reads, F specifically reads, "where available, a certified copy." And we haven't obviously appealed that. So that is the status, and it was specifically to address the difficulties raised in the application.
Just to quench my curiosity, Mr. Jamie, on something that is not raised.
Certainly, Justice.
In the event of a dispute arising, the father seeks to notify Home Affairs of birth, and therefore seeks to have his name or surname reflected there. But the mother says, no, but you are not even the father. Is it Home Affairs that resolves that, or is it at another forum where that is resolved?
As we understand it, Justice, Home Affairs would not get involved in a dispute between two alleged parents. But on the other hand, for the reasons I've already submitted, they would have to verify the information. And certainly that would be a red flag if the parents, supposed parents, are in dispute. So a conscientious Home Affairs official would have to conduct the necessary verification exercise. And to the extent that that involves DNA testing,
they'll probably ask them to go and resolve their differences first.
They would certainly, a conscientious officer would require some sort of proof of paternity. And of course, that goes for any information provided to Home Affairs. They always can ask for verification. And certainly in the situation you are putting to me.
Thank you, Mr. Jamie.
As the court pleases, sorry.
I'm sorry, CJ. Mr. Jamie,
Justice Drafter, yes.
I would like to know, my understanding was that the full court only declared Section 10 invalid. Now, how do we reach Section 9 and declare part of it invalid?
Sorry, Justice Drafter, if you are with me on Section 10 being struck out, then what remains, the reference to Section 10 in Section 9.2 is incongruous. And even if it's left, if it's left intact, which would not be an elegant solution, Justice Drafter, it would be superfluous because there would be no Section 10. So it would be regarded as pro non scripto to anyone requiring to interpret Section 9.2. There wouldn't be a Section 10 to make it subject to. It doesn't, with respect, raise any constitutional issues in our submission. It's simply, if you're with us in respect of Section 10, then it's a necessary tinkering with Section 9.2. It doesn't raise any specific or distinct constitutional issue. I don't know whether that answer assists you, Justice.
The tinkering must be based on constitutional grounds, isn't it?
Yes,
I hear the point that you can leave it as is, it doesn't matter. I hear that point, but I'm concerned about the tinkering. You have an order that declares and limits itself to Section 10, and you're considering whether you confirm that declaration of invalidity. Now you go outside that order, and then you tinker with another provision which was not covered.
Justice, it's a principle, as you know, of our law, the legality principle. One of the manifestations of the principle of legality is that laws must be clear, and that we know from cases like Darwood in this court. And in my respectful submission, it is well within the powers of this court in terms of Section 172 to make an order that is just and equitable if you find, as we submit it is, Section 10 is unconstitutional. The necessary, and I don't mean any disrespect to anyone by using the word tinkering, but the necessary almost keyhole surgery which would be required in respect of 9.2 is well within the powers of this court in these proceedings to say, if we strike a line through Section 10, obviously Section 9.2 must have that particular wording. And I'll emphasize it is with respect, not except in the context that I've just submitted. For the interest of clarity and legality, it's necessary that the law be clear as can be. And that is the constitutional concern that we would raise in supporting the minor rewording of Section 9.2 to remove the reference to Section 10. We submit that would render the section constitutionally compliant in as much as it would be clear. But it raises no other constitutional concerns.
Thank you.
As the court pleases.
Jamie, I have a similar, not a similar, I have a problem that goes further than that. You are asking now for us, if I understand it correctly, to jettison the entire Section 10, and you say in your heads that you rely on Phillips for that. But Phillips, you cited paragraph 9, or it's actually paragraph 8. Phillips said no more than that. If proceedings are unopposed, then confirmation by this court of an order of invalidity does not follow as a matter of course. This court has the duty still to evaluate the legislation, the impugn provisions, and to decide whether it is in fact invalid. Our difficulty is this: the High Court only was asked to, the full court was asked to, and only declared part of Section 10 invalid to the extent that it does not permit unmarried fathers to register children under their surname in the absence of the mother. And that is the relief sought by the applicant. Now, can we go further and grant relief, which the full court didn't grant, which an order of invalidity, which doesn't go that far, and that in any event was asked for in the notice of motion by the Child Law Center, only to the extent of that part of the section? Can we go further than that? And as I read Phillips, Phillips is not a direct authority for the proposition you make.
Justice, that is an issue which concerned us. We've thought about it, we've discussed it. And our submission is that to the extent that the court only follows what and we understand there used to be confirmation hearings of a particular order of constitutional invalidity. But we submit at the end of the day, this court is obviously concerned with the constitutionality of the law, which is now sought to be impugned. And we submit that if the court quo's findings or conclusion does not go far enough, as we submit it doesn't, then it is within the power of this court to make an appropriate order, having heard the parties. And I can't take that matter further, because I'm fully aware of the limits of Phillips, Justice Majid. But we submit under Section 172, this court would be entitled to make that order.
Well, there are also decisions of this court which deals with frontal challenges to constitutionality of legislation. And those decisions clearly say that the court, first of all, there must be a direct frontal challenge to the section in question or sections. And secondly, the court must move within the ambit of what that challenge is. Now, we are being asked here to move far beyond the challenge that was originally before the High Court first and then the full court. And the full court then, in overruling the High Court, declared the section only unconstitutional to a certain extent, as prayed for. So without the benefit of a full proper challenge on proper facts and legal argument, and without proper legal submissions, how are we empowered to go that far and strike down the entire Section 10?
Justice, the submissions that I made to you are founded on what we submit is a proper consideration of the of the section. I'm aware of the limits that decisions such as you are referring to place upon the court, and those limits, as we understand them, are primarily to ensure that the court does not make orders which have not been properly considered. Here, with respect, my client, as the custodian of the relevant legislation, has identified a difficulty that goes further than that identified by the applicant. We accept that. If the court is not with us and considers that the principal relief that we ask for goes too far, then we, with respect, would submit the alternative, which is set out in para 63 of the heads of argument, better addresses the concerns than that proffered or suggested by the applicant and by the court à quo. And we submit that certainly would be within the court's ability to make such an order.
Thank you, Mr. Jamie.
Mr. Court, please. Unless there's anything else, Chief Justice, Justices, those are our submissions.
Sorry, can I just, sorry, Chief Justice, just one question.
Certainly, Justice.
On the question of the lack of a frontal challenge,
yes.
Would Section 28 of the Constitution not allow a substantial degree of flexibility in trying to rectify what is really a child born out of wedlock and the prejudice that goes with that? Does Section 28 help in these circumstances?
Section 28, as the court is aware, provides that in every matter concerning a child, the best interest of the child is paramount. And we submit certainly it would give force to the argument that a piece of legislation which quite clearly in our submission I've described it as hearkening back to the past, that is not permitted to remain on the statute book. But I must also accept the difficulties put to me by Justice Majid. And obviously, to the extent that this court does not see fit to make such an order, striking out Section 10 in its entirety, the legislature obviously can address it. And that would be, so it's not that, it's a lost cause altogether. That provision can be addressed if it's regarded as more correct, constitutionally proper, can be addressed by the legislature.
Mr. Jamie, on costs, you say that there should be no order as to costs. Do you accept that the applicant had to approach the court for an order of invalidity? And if so, why do you say it should not be granted its costs?
As against the Department of Justice. Well, the department did not, as you know, and I just want to make sure whether...
That is, even if the department had not opposed, it had to go to court to get an order of invalidity of this particular section, and also come to this court for a confirmation of the order of the High Court in terms of Section 172.2.
Yes, yes. No, it certainly had to obviously, because of the Constitution itself, come to this court for confirmation. And we with respect, and I'm just looking at their heads of argument, and I don't know whether my learned friend is going to deal with it in reply, whether they seek costs against the department. We certainly have made the submission that for the reasons in our heads, costs should not be granted. And with respect, this is not a case where the organ of state has been in any way, has contributed, as it were, to the running up of costs.
But even if that be so, Mr. Jamie, even if that be so, why should the applicants be out of pocket? In a situation where they just had to go to court.
Yes.
Why should they be out of pocket?
Justice, on the basis of Biowatch, we know what Biowatch says. They have asserted a constitutional right. They've been obviously substantially successful. It was necessary with respect, and depending on how the court goes with regard to the remedy, the interim remedy, our participation at this stage would either have been of assistance or not. And to the extent that you don't make the order sought by the applicant, we submit it's at least possible that the court would consider not making any order as to costs. But if the court applies Biowatch, then we accept that costs would follow the event, as it were.
Do you accept, Mr. Jamie, that it fell on the shoulders of your client to correct what is constitutionally objectionable in this act? And we are 26 years into democracy, and that has not been done.
I accept that unreservedly, Justice Jafta.
Thank you, Mr. Jamie. I was just asking in relation to costs. Yes.
No. So, certainly, the sin is an original one, and we don't attempt to get away from that. It happened on my client's watch, and we must take the necessary pain.
Yes.
Unless there's anything else, Justices, those are our submissions.
Thank you, Mr. Jamie.
Thank you, Judge. Chief Justice.
Mr. Beamer.
Thank you, Chief Justice. Chief Justice, just on the question of remedy, I don't propose to be too long. The proposal by my friend, Mr. Jamie, that Section 10 be struck off in its entirety is an appetizing one, because Section 9 seems to cover what the Act seeks to facilitate, which is birth notification, along with the regulations that attach itself to Section 9, which is Regulations 3, 4, and 5. And the court will note from those regulations that there's an extensive list of documentation that's required to be provided by parents who wish to register their child. So Regulation 3 deals with on-time registrations, Regulation 4 late registrations, and Regulation 5 registrations after a year has passed since the birth. Though I can appreciate the difficulty that the court may have in the legality issue, and I think the approach that the court should take is to interfere as little as possible with the current wording. And this takes us back to the approach taken in Satchwell. So where we're dealing with under-inclusiveness, we must seek to create inclusiveness and let the final issues be dealt with by Parliament. Though, seeing that the attack is on Section 10 only, perhaps a wording that mirrors the provision of Section 9 might be a more favorable approach to rewording it. Though I think, if anything, the fact that the debate around wording has caused so many problems tends to show that perhaps the issue is best left to Parliament. And Home Affairs will then have to regulate for the permutations and eventualities that might that might arise in birth notification, whether it's within or outside of wedlock, and whether it's the father who is the person giving notice. It's a precarious position to be in, and I take the points that my friend Mr. Jamie raised about how inclusiveness is created in the Act. The last issue I want to deal with is costs. And it's true that the Centre has asked for costs, though if we stay true to the wording of our notice of motion, it's costs only in the event of the respondents opposing the application for confirmation. And to be fair to my friends, for the state, they had filed no affidavit in these proceedings. I think the only thing they filed was the heads of argument. So I think one way or the other, the Centre is happy. unless there are any further specific issues, that is my reply, Chief Justice. Am I on mute? No.
Justice Kampepe.
Mr. Pima, thank you very much. Do we have any questions to put to Mr. Pima in reply? Colleagues?
No.
Nothing from my side, thank you.
Thank you, Justice Kampepe. If there are no further questions, that is my reply.
Yes. Justice Kampepe, you're on mute, Justice Kampepe.
Thank you very much, Mr. Pima and Mr. Jami. The court is adjourned and judgment is reserved.
Quickly, Michaela.
Today's hearing is concluded. You may now leave the meeting.
As the court pleases, thank you.
As the court pleases, thank you.